All right, if we could call our session. Everybody, time to take your seats.
Is this on? Catherine, do you want this?
I have a very loud voice.
Okay.
I think everyone can hear me. My name is Catherine Korn. I am the board chair for the Estate Planning and Probate Division of the Contra Costa Bar. And today I'm very, very happy that you're all able to attend our Contra Costa County Assessor's implementation and perspective on Prop 19, which I think has confused all of us on occasion since it was implemented, what, a little over a year ago, 2021.
2021.
Yeah. So before we get started, I'd like to introduce our sponsor, Jonathan Kerniati, who is with Kerniati Realty, and I'd like him to say a few words. Thank you.
Good afternoon. Thanks. It's a pleasure to sponsor the estate planning and probate section. And before I'm Jonathan Kerniati, real estate broker handling family estates, but I have a real quick joke for you, real quick. Okay, so police officers stopped a speeding motorist and walked by the window and asked, may I see your real estate license, please? And the motorist said, no, don't you mean my driver's license? And he said, no, not everyone has one of those, you know. So anyway, I only mention that because we're at the section this morning with the general counsel of CAR, who said that there are about 220,000 different realtors out there, and the question is, do you have the right realtor that is serving your clients' matters or so? And I'll be quick, but I used to sit in the civil litigation side. I did civil litigation for a long time, but now since 2011, just been working with clients in family estates because I want to make sure that we're careful with disclosures or where we're exempt, and also make sure we guide our clients to competent closing of the transaction, because some of you have probate administration cases that have sat there with sometimes holdover family members, difficult situations, and I like to try to take care of my clients with kid gloves, but also keep them diligent in that. Last thing is I have a sponsorship table out there, and if you haven't dropped off your business card, there's a drawing at the plenary, at the end of day session for a $200 gift card to Fleming Steakhouse, but I'd love to talk to you about what I do in my service, okay? Thanks for being here.
So I'd like to introduce our two speakers and our moderator, who we know and love, Esther Kim, who is one of our board members and will be coming on as a co-board chair in January this year of our section. Tanay Jackson is a graduate of Cal Poly San Luis Obispo and then moved up luckily to the Bay Area for us. She's been a real estate appraiser for quite a while and started with the Savings and Loan initially. She currently is the principal appraiser in the Standards Division in the Assessor's Office. So I was very pleased to meet her and get her phone number, because when I have questions about Prop 19, this is the person we can all call. Thank you, and thank you for speaking today. And then we have, of course, Gus Kramer, who has been our assessor since 1995. Long career and has worked diligently with the county. Very interesting, graduated from both SF College and San Francisco Mortuary College, correct? And I believe he initially started with the coroner's office here in San Francisco. He worked with the probation department and worked with Public Works. And I do remember in 1986 when you were the clerk for the county, correct?
I ran for clerk recorder and got my head handed to me on a plate.
Oh dear. And then came to the assessor's office. We've been very fortunate to have him ever since.
Thank you for reminding me.
My pleasure. So with that, I'll take it away. Thank you.
Okay. So thank you so much for coming to the presentation. I think you will find it really interesting and informative. Just a couple of housekeeping announcements. Oh, okay. Yeah, the temperature in here is frosty. We've asked maintenance to see about warming it up a couple of degrees, so hopefully that will happen during the presentation, but I don't think anyone's gonna fall asleep after lunch because it is frosty. The presentation that Tanai and Gus are gonna do is gonna last about an hour, and then we'll have time for questions. We would like for you to hold your questions until after the presentation, and then we can address all the questions at that time. And if you haven't already signed in in the back table there with the sign-up sheets to make sure you get your MCLE credit, please make sure you do that. And there's also an evaluation form that we would really value getting your feedback about the session. Okay, so without further ado, I'd like to introduce Gus Kramer. He is going to be talking about the history of Prop 19 and the impact that it's had on the assessor's office. And some of the challenges that the assessor's office is facing because of the implementation of Prop 19. So, Gus, take it away.
Thank you. Do I need this? Oh, here we go. I have trouble talking when I'm sitting down. Let me stand up. Assessor's office is an interesting place. We have about 120 employees. About half that staff is appraisers, and the other half are support staff clerks. And Tanai is a principal. She's a division head of the kind of our control in the office. She's kind of the person that keeps everybody else honest. So Tanai's a good person to know, and especially with Prop 19 because that's fallen in her lap. And she's done a stellar job keeping up on it. Other counties are not even doing them. I don't know if you run into that or not. LA actually stopped doing them for like 6 months because the board of supervisors wouldn't give them additional money and staff to help work it through. So it was a very politically contentious issue. About half of our work in the assessor's office is doing things like Prop 19. It used to be Prop 60 and Prop 58, the parent-child transfer and the senior citizen transfer. And there's a plethora of other propositions that passed since 1978 when Prop 13 passed that we have to administer. And we do it under the auspices of the State Board of Equalization, and they oversee us, and they come in and they audit us, and they pat us on the head and tell if we've been good or not. To Tanai's credit and her staff and the rest of the staff in the office, we have had the best scores of any other county, other 58 counties, other 57 counties in the state of California in the last 20 years. So I like to take credit for that, but I have to give credit to Tanai and her staff. You guys truly she makes me look good, and that's very important. I like your cop story, but I have a true cop story joke for you. When I started in the sheriff's office, they took us out on patrol, and though I was supposed to work in the coroner's unit, they didn't have the morgue ready for us yet. So I'm out with a guy, and we pull over a Mercedes-Benz on Mount Diablo Boulevard in Lafayette. And the officer I'm with, we both get out, and typical custom, you both go on each side of the hood. And the guy gets out of the car, and he's dressed really nice, got a coat and tie on. He says, "What did you pull me over for?" He says, "Well, you were speeding, sir." And he goes, "I'm an attorney, and how dare you give me a ticket? I'm telling you, I pay your salary, and I don't want a ticket today." And the deputy I'm with reaches down. You gotta remember, it's before cell phones and before the county could afford really good radios. So everybody carried a dime or a quarter under their belt so they could use a payphone to call in. This is 1974. This guy reaches under his belt, pulls out the quarter, drags it across the hood of this Mercedes, and the paint is just chipping up. And he says, "Sir, here's a part of my salary you paid last year. Thank you very much." And we got in the car and drove off. Now, this is the mentality of what police work was like in 1974. This truly, and I'm looking at this guy going, I'm gonna lose my job. I'm on probation. I got a family to feed. This is insane. And this guy's looking at me and says, "Don't worry about it. He'll be fine." We never heard about it. Never heard about it. So think about how you would handle that as your paint chips off the hood of your car. Anyway, can't make this stuff up. In the assessor's office, everything was bumping along, fine and dandy. until Prop 19 passed. Prop 19 was a metamorphosis of other failed propositions that had come before the electorate in the last 6-8 years. There was a proposition to make it so that when you were over 55, you could transfer your property tax without getting it reassessed for five times. I think it was Prop 5 or something like that. And then there was a couple of other propositions that came up that failed very shortly, but they did fail. So the opposing parties in this malaise of politics gets together, and that was the State Board of Realtors, and the firefighters and another group. I think it was the Nurses Association. And they put together Prop 19, and they wrote it, and I mean this from my heart. I know they didn't have an attorney in the room because it was written like a bunch of 6th graders. They had words that contradicted each other. They weren't consistent in the use of the word regarding real property. They called it real estate, real property, estate property, and almost like they almost thought you could interchange it because of what they were thinking, but they didn't transfer that thought to the paper. So the State Assessors Association, myself included, approached them before they actually went to get signatures, and we begged them to let us participate and clean up the language, because what they were proposing was not administrable. It just wasn't. It wasn't legally administrable. It wasn't realistically administrable in the office. They told us to mind our own business, and subsequently it passed. Well, when it passed, I can't think of the office in the state. Anyway, the state attorney's office came out and said, "No, you're right. This doesn't make sense. This needs," and you've all heard this expression, "this needed cleanup language to make it work." So the parties then were all sat down. We get some pretty good cleanup language, not totally, but that took about 4 months, 5 months to get through the process, through the state legislature, and everybody wanted to put the little trailer bill on it. Everybody wanted to put their 2 cents on it. So they finally got it through in September, and the governor, I think the governor sat on it for like 2 or 3 months. So here's all these people thinking on February, whatever date it was, 2021, they were able to do a Prop 19, sell their house in another county, and bring that value to Contra, Costa, or any other county, and enjoy their lower Prop 13 tax base. Well, they could, but there was no process to make it work, because when you do that, the county you're going to puts a value on the property, and then we have to contact the county you came from and ask them to certify the value of the house they sold. And all this has to go through also a clearinghouse in Sacramento through the Board of Equalization, so they can keep track of these. They didn't have a process for that. Nobody had set any of this up. It was all going by the seat of their pants through the whole process. We decided in Contra Costa not to hold up people on their Prop 19s, and we decided to go forward and grant them to people, provided everything looked relatively kosher. If it looked wonky, if it looked like somebody was playing a game or not being honest and forthright with us, we would ask them to certify or substantiate that information. But we have processed, I think, about 80% or 90% of those have come through.
For a base transfer, for sure.
Yes.
Yeah.
So it's worked pretty good. Other counties are not doing it at all. So we had a case recently where, usually people are moving into Contra Costa County, and they're moving from high rent districts, I call them. They're moving from Santa Clara. Well, 50% of the Prop 90s Prop 19s that come into Contra Costa are from Alameda County. I was shocked when I heard that. I thought more would be coming from Santa Clara, San Francisco, San Mateo. There are a lot of them, but 50% are coming from Alameda to Contra Costa. And the reason they're coming here, almost without exception, ones I've talked to, it's people my age and their children have moved to Contra Costa because it's affordable housing compared to where they live now, and the grandparents want to be closer to the grandkids. Almost without exception, that's the case. They want to be closer to their kids. In my case, I can't wait for my kids to move further away. I just go away. But to each his own. So that is where the numbers are coming from. We recently had somebody move to our county, and they came from the poorest county in the state. Anybody know what county that is? What? No? No? No, close. It's Calaveras. Calaveras and Tuolumne County are constantly in a battle for being the two poorest counties in the state of California. It's their own doing. It's their own doing, trust me. But we were waiting for them. The property owner moves here, wants their lower base, and we send them a supplemental tax bill, which is driving them right through the roof. And tonight's done everything. Tonight, our staff have done everything the law says we should do, except Calaveras County didn't have enough staff to certify the value. So that was holding these people up. So those are the type of things we've decided to look over and say, look, okay, we're gonna give it to you, but these people do have to come through eventually. We'll clean it up later. It's a difficult administrative decision we have to make on a case-by-case basis. And sometimes the property owners make it difficult, and sometimes it's just the other county that makes it difficult. But remember when we had the old Prop 58, no, Prop 60 was the parent-child. I mean, Prop 60 was the senior program. You can move within Contra Costa. You can move from one town to another and take your base with you as long as you bought down or equal to. You couldn't buy up. And that really stymied a lot of people. This new proposition, you can buy up and you transfer your base to the new property, and if you actually bought a more expensive home, you just pay the difference at 1%, as if you buy a regular house, a new house. So you can bring your base with you, it's nice. The basics of it are the same. If you're married, one of you has to be 55 or older. And if you are married and use it, you can use it more than once. You can do it 3 times each. And if you're married, you have 6 opportunities to move. It sounds a little excessive to me. Statistically in the state, the average person who applies for a base year transfer, whether it be Prop 60 or Prop 19, the average age is around 72, 73 years old. And after working at the coroner's office, I can give you these statistics. Most people move twice when they sell their home. They move once to their second home, like we're talking about, and the next move is either to assisted living or the cemetery. So having 3 moves seems excessive. Having 6 moves is an opportunity because of the way it's written is almost ludicrous. And let's not forget, you need to know this for your clients. If you have a client who needs to move to a single-story home, and for any reason they've run out of options under Prop 19, there's a Prop 110 that allows you a note from your doctor saying you can no longer be in a two-story home, or your home is a split level, you need to be in a one-story home. With that, you can buy an equal value or less. Can you buy up? In the 110, we can't buy up. can we?
110 now is covered under Prop 19.
Oh, it is covered in 19, so you could go up. But you can't, you can only do that that's your last step you want to take. You can't do a Prop 110 and then come back and say, you know what, I don't like this house. I'm going to find another one. You can't do a Prop 19 after you do a 110. So that's your last resort. You keep it in your pocket as your safety net. Prop 19 is so popular that we are doing 4 times as many of those types of transactions as we were the regular Prop 60s. And it's been a great opportunity for people. I'm just noticing, I just came from to move within their region. That's where we're seeing most of these moves are. I was talking to the assessor and from San Diego and Los Angeles and Orange County, and they're not seeing people moving from Contra, Costa, or Alameda down there. They're seeing people move from one county to the other, and their reason for doing this is the same as it is in Northern California. They're trying to get closer to their kids. That's all they're trying to do, and their grandkids. So it's turned out to be a really good proposition. The one element we lost with Prop 19 was you can no longer, if you have a second home or some investment properties, under the old proposition, you could transfer up to $1 million of assessed value, not market value, what you were paying in taxes on it. So if you bought a tilt up in Concord for $200,000 20 years ago, and worth a couple million today, you could still transfer that to your children, and they get your base. You cannot transfer anything else except the home you live in to your children now. And they have to get a homeowner's exemption and live there. Now, one part of that I find interesting is we've got about just as many of those as we got before, about 400 or 500 of those a year. Well, needless to say, in 10 years, we'll have 10,000 of them, maybe. And who's going to police all those people to make sure those people are living there? I don't have staff for doing that. So it's going to be a unenforced regulation, to be honest with you. But remember, you cannot transfer your second home in Tahoe or your second home in Santa Cruz. You can't transfer that to you can transfer to them, but they're not going to get the benefit of your Prop 13 base. That's gone. The only thing you can transfer to your kids and get your Prop 13 base is the home you live in. And I highly recommend, if you don't have it now, or your clients don't have it now, tell them to apply for a homeowner's exemption. It only saves them $70 a year, but it demonstrates they're living there, and it makes it a lot easier for us to go through the process. With that, I'm going to turn this over to Tanai, and she's going to share some real important stuff with you. And we don't have handouts on those numbers, do we?
I have brochures.
We have brochures. We have brochures if you want them after the presentation. She's going to show you some basic formulas that you could use or back into with your client's information if you so wish. And ladies and gentlemen, Tanai Jackson.
Thank you, Gus. We are going to have Tanai walk us through some of the nitty-gritty parts of applying for the parent-to-child exemption from reassessment when we're talking about a primary residence. And I just had something in mind. Oh, the materials are going to be available to you after the presentation. We will send them out to you. So the PowerPoint, as well as any links to information, will all be available to you after the program. Okay? All right. Take it away, Tanai.
Thank you. Can you hear me okay? All right. So We'll be talking about Prop 19, the intergenerational portion. Gus went over a lot of the, other parts of it as far as the base transfers, but my presentation is centered on the intergenerational portion. And so one of the things, but I do want to mention that the base transfers, there was an article that came out, I believe, in the San Francisco Chronicle about the Bay Area counties, and Contra Costa by far had the most base transfer applications under Prop 19. And so I'm really interested, we have to do state reporting each year, what our intergenerational applications will look like versus other Bay Area counties, as well as really the other counties in the state. We received about close to 800 intergenerational applications since last year. That is a big number, but also really a small number compared to Prop 58. Prop 58, we would get anywhere between 3,500 applications to 4,000 applications a year. So I expect there to be a significant decrease, but the 800 applications is more than I thought we would receive since the passing of Prop 19 in 2021. And as also as Esther said, I'll stop midway to have just basic questions before I get into the examples of how we're calculating the new taxable base, but we want to make sure we can get through all the information. And so if you're familiar with the prior parent-child exclusion, was called Prop 58. The grandparent-grandchild exclusion was called Prop 193. And when you look at the two props, Prop 19 is so much more restrictive than what they were before. I mean, I know you know that, but I think, I can't believe it, how restrictive it is. I know why. We know why they did it so restrictive, but it's just not beneficial to the taxpayer at all, especially when you're going through kind of that time, right? Your parents, in most cases, the parents have passed away, and so now there's just this little narrow window of where you can apply for a Prop 19 and get your parents' base. You may not even get your parents' base after we do the calculation. So the biggest difference is, as Gus said, is only your primary residence, the primary residence of the transferor, as well as the transferee. You have 1 year to establish that, to apply for the homeowner's exemption or disabled veterans exemption claim form to establish that that is your primary residence. And now the additional restriction is that there's a value limit test. And so that's the current tax base plus $1 million, and that's compared to the market values of the date of transfer, but we'll get into that more. So we are looking at changes in ownership when we're looking at that Prop 19. So it could be a sale or purchase, gift or inheritance, voluntary or involuntary. I wanted to put the slide in here. We all know what a change in ownership is, but we get a lot of calls from our office where the taxpayer says, oh, the property's in a trust. My parents' death was not a change in ownership. It is a change in ownership. So I just wanted to mention that. If you have questions, we can do that at some point. But again, Revenue Taxation Code, voluntary or involuntary, purchase, gift, or inheritance. And so one of the other things that we see for this is that under Prop 58, the parent passes away, you know you're going to sell the house, you and your siblings decide we're going to sell it. Under Prop 58, you could apply for that claim and still pay your parents' base until you sold the property. Under Prop 19, that's not the case. Eligible transferor and transferee, it can go back and forth. Most of the examples we're using are parents passing away, but it can be either or. Child to parent, parent to child, grandparent to grandchild, and even grandchild to grandparent. In the case of a grandchild, it's limited circumstances where we can grant that exclusion, and the biggest one is that the parent has to be deceased. And we'll go over the application a little bit, and there's basic questions about the death of the parent to qualify for the grandparent-grandchild exclusion. Again, primary residence, the revenue taxation code also states primary residence and family farm. We don't have many family farms, so I won't be mentioning it, but family farm is included in that. Again, 1 year to establish the primary residence of the transferee. If that property is no longer the primary residence, then we have to remove the Prop 19 exclusion. So my boss here said we're not going to be tracking that, but we do have ways to track it. And so we haven't instituted it yet, but we are talking about it with myself and the IT person and how we track if that homeowner exemption basically has been removed from the property. So when I talked to Esther last week, she was asking, hey, what if the beneficiary moves out of state? And so it's possible to still keep that Prop 19. In limited circumstances, we would be able to track it, but say you know, your client moves out, maybe they have a family member live in the house. So they would still basically be able to keep that homeowner's exemption, because in the state of California, you going typically have a homeowner's exemption on one house. So it's only if you then say, oh, I'll apply for the exemption, the Prop 19, and then I'll rent it out, then you go put the homeowner exemption on your primary residence, we're going to remove that exclusion.
We are?
If you say so.
I'm joking.
I know, so, again, like I said, just so much more restrictive for the taxpayer, when it comes to the situation. The filing period is similar to Prop 58, so you have 3 years from the transfer date or before transfer to a third party. And we could talk about how that plays out with the 1 year, having to establish that 1 year, that is your primary residence. Notwithstanding above, within 6 months of mailing of the notice of supplemental assessment or escape assessment, and if all deadlines have passed, and this is really where we're leading to, prospective relief for the lien date of the year claim if filed, as long as the applicant, you know, all other criteria are met, then you'll get your client will get the benefit prospectively. I'm going to put on my glasses now. So this is just a basic claim for reassessment of parent-child applications called the 19P. The document is not subject to public inspection, and I also want to suggest to not record this document. Sometimes we get the call, hey, I turned that in, we didn't get the document, the application, Prop 19 or Prop 58, because it's recorded with the whatever, affidavit of death or whatever document was recorded, they recorded this, it goes along with the preliminary change of ownership. We have access to it, but the clerk recorder's office, they don't care. So sometimes we get it, sometimes we don't. So just a note, have that application come to our office, and like I said, you can record it if you want to, but I would suggest you not record it. When I say it's not open for public inspection, there was an incident where a family wasn't happy with the appointed successor trustee. They felt that he wasn't doing his job. I don't know if you have experienced that. He wasn't doing his job properly. And they also did not have a copy of the most recent trust. And so they went to court, and the court said they had to have the most recent copy of the trust, and they subpoenaed our office. I got a subpoena via email every other week, and I told them we can't do that. And so we had to get county counsel involved, and they told them again, we can't do that. So just know that they couldn't see the application. The successor trustee that we had on file was their brother, and they couldn't get it from us. They weren't happy.
So now I have a quick question.
Yes,
This form is a new form, right?
yes, yes.
And so, have you come across this problem in your office where people are filling out the old form and asking for the Prop 19 exclusion, but it's based on?
Absolutely, absolutely. In the beginning, we we receive that a lot. We're starting to not see that as much. As Gus talked about, the law was passed in November, late November of 2020. And then the intergenerational portion went into effect February 16th, 2021. I mean, that's bonkers for, you know, we're not the biggest, but we're a bigger county office. So we were able to kind of jump in there and get them processed. But when you talk about the smaller counties or the poorer counties, I mean, it really is a burden to them. And I know that's some of the conversation that's going on is even how to process the application. So what we did is we sent a denial letter. So we wanted to, because it was so new, we wanted to let the applicant know right away, like, you gave us the wrong application, so send us the right application. We didn't sit on it, or we couldn't process it without that one. We would even just send the Prop 19 application and say, just sign it. Everything else was complete. They pretty much, in some cases, they pretty much mirrored each other. So if it was enough information, we just needed that signature on the Prop 19 application. So I talk about successful tips for applications. That's the number one, pick the right application and make sure it's completely filled out. So when we're looking at this application, like I said, it's a typical government form. It's pretty dense, a lot of information. We typically get these applications that are not completely filled out. So I just say the top section is Section A. If it's a date of death, put the date of death. If it's the date of transfer, you're just transferring. You know, the parents are alive and the children are alive and they're transferring. Put that date of transfer. We have ways to look it up, but that just takes more time for us to then go find everything that we need to process your application. The big component, again, is the homeowner's exemption. So that's this section, the middle one is on the back of that form. And it asks, is the property going to be the transferee's principal residence? We got a lot of applications that said no. I mean, that's the component, you have to live there. So and I'll just tell you, we didn't even read further. If you said no, we denied it. So people received denial letters because they marked no. We then got calls back, we didn't understand what that meant, but we asked for additional documentation so we can go ahead and process that. So, you know, just make sure it's completed and it's completed accurately. Name of transferee, you want to go ahead and put that on there. So when we're looking at applications, the just basic application is parent passes away, a single beneficiary, that's easy, right? So if we're looking at something else, something a little bit more complicated, one of your siblings is going to receive the property, then that's a little bit more complicated. But either way, try to be as complete as possible on the application. The bottom of the application on the back is signed under penalty of perjury. So we typically will take your application at face value. But if things don't match or we have to do further research, we may need more information. So we'll reach out to you. Make sure you put your phone number. We'll reach out to you either via phone, email, or letter and ask for more information. If you know, you have to you have to send in the complete trust, whatever the case may be, we may have to ask for more information.
So I have a question about timing. When you're applying for the homeowner's exemption, can you submit that at the same time as your Prop 19, or do you have to have that prior so that you can write in the date, this is when it was submitted and claimed, or can you do it all together as one?
You can do it all together as one. But you were saying, say it again about why wouldn't you put them all together? Maybe that's what I missed. Like if they're moving at a later date, they're not sure what date they're moving in?
Or maybe it's there's several beneficiaries, like, you know, several kids, and they can't figure out which one they know in order to get it, they've got to file this homeowner's exemption. And they're trying to figure out which one of the kids is actually gonna live in the house.
Okay.
So, I mean.
I see what you're saying. And that's what we're finding too. Like there's a percentage straightforward, but there's a percentage where people don't know. And that makes sense. And so what we say is complete the application the best you can. If you have to amend it, and the good thing about it is that, you know, I don't think that'll happen too often, but different beneficiaries can live in the property. So if you know today it's going to be Brother Joe is going to live in it, that's fine. And then you could just put Joe, and then if sister's gonna, move in at some other time, then they could just move in. They could either apply for a homeowner exemption under their name, but either way, that Prop 19 exclusion will stay on as long as beneficiaries are living in the property. Again, it's just the 19G, the claim for reassessment exclusion for the grandparent-grandchild is a different form. And so in some cases, you may have it where it could be a parent, the parent passes away, a child is a beneficiary, and a grandchild could be a beneficiary because their parent has already passed away. So you would have to then submit 2 different applications. Again, name of the direct descendant of the grandparent who is the parent of the grandchild, and we ask for the death certificate of that parent. Then there's further questions as far as if that parent was married or in a registered domestic partnership, because if they were, then the grandchild still doesn't qualify for the parent-child exclusion. So they would either have to be remarried or a step-parent or deceased. Yeah. The homeowner's exemption claim now is online. We didn't have it online before, and that did present a lot of problems for people, but we did put that online. So now you can submit that homeowner's exemption claim as well as the application to our office, and that's really helpful. We spent a lot of time with the homeowner exemption department trying to match up applications. That we do not have a way to track yet. If you just send it in, there's no way to say this homeowner exemption is for a Prop 19 application. So in that case, we just spent time trying to match them up. So now you can submit them at the same time. If for some reason you can't, it's fine. You can still turn in your application, especially given where the law is going. There's emergency amendments. I haven't found where they've been written in, but they're saying the homeowner's exemption claim can be filed after a year, but then we would grant that exclusion prospectively. So the state is still trying to figure a lot of things out, and that is one of them. But again, if you can fill out that homeowner exemption claim at the same time, that'd be great. If you can't, at least get that application in.
Tonight, could you just qualify what you said about the relief would be prospective? So there could be a reassessment because you didn't file the homeowner's exemption, you get denied, you get a supplemental assessment, and then you file later the
Yes.
homeowner's exemption. So then going forward from there,
Then you would, as long as everything else was adequate, then
Right.
you would get that Prop 19 relief moving forward on your next tax bill.
so no refund.
No refund, yes.
Okay.
And they're and like I said, it was just in the emergency proposal, but they were saying no refund for any prospective relief. You would basically still be responsible for your supplemental bill and however long you were paying at the difference of the market values at the date of transfer. Again, just like I said, there's basic government forms, but it does help us if everything matches. When did you acquire the property? That would be the date of transfer or the date of death. And so we want that to match what your application says. Date you occupied the property as your principal residence. And so right now we have a number of applications, not a lot, but there are instances where a beneficiary did live in the property with their parent. They're their parent's caretaker, and now their parents passed away. So they still are applying for this homeowner's exemption to qualify, but they still are selling the property, but they live there. So we put those applications to the side to make sure that we are kind of following the spirit of the Revenue and Taxation Code, but we may have to interpret it our way, because I don't think that it's fair to reassess them if a beneficiary has been living in the house as a caretaker, and now they have to move out now that their parents passed away.
So just to follow up, so earlier you had said, if there was a parent that passed away and the beneficiaries are children and they know they're gonna sell the property,
Right.
and and they're gonna do that before the year is up, so they don't even have an opportunity to make a claim for the
Right.
the homeowner's claim. You're saying deny.
Deny.
But if the child was living in the house with the parent as a caregiver, then that is, that's.
Or they were just a loser, couldn't, find their own housing.
True, okay, whatever the circumstances.
Whatever the
Chances are that they are living in the house.
Yeah.
That would be a different situation. Even if they were gonna sell the house, the time period that they were living there would help them to qualify.
Would help them to qualify. And like I said, we put those applications to the side because we begin to call. I mean, again, this is just so gray and it's so different. And so at the same time as taxpayers have questions, we're trying to figure out how to evaluate those situations. And like I said, it's just my opinion that wouldn't be fair to deny those. And so that has gone on a special pile that we're reviewing. But as, you know, as time passes along, I just don't see why we wouldn't go ahead and grant those. We would ask for additional documentation to prove that that child lived there. But other than that, I don't see why we wouldn't. So that's where we are now. We haven't made the determination, but now that I've kind of spoken it to you guys, I think that's the direction we're leaning, is to go ahead and grant those. But do know that we do have access to like the MLS. And so if your house is listed and it says it's vacant, your parent passed away in February and it's on the market in, you know, March, April, vacant, all the, you know, in the pictures there's no furniture in there, we're not gonna believe that, you know, we just may need more information in those cases. So we are looking at these. Like I said, we still wanna follow the spirit of the revenue taxation code, but we also want to be aware of, you know, what the change has done to basically, you know, basic family, basic taxpayer.
Okay,
If
great.
that makes sense. So are there any other questions? Because now we're going to go into the valuation tests and examples, and so I'll be happy to stop here. Well, you first, so.
Yeah, so, I think from a practical standpoint, one of the things that we've come across is that, you know, that we have to do the death of real property owner within 150 days of death.
Yes. Mhm.
Even though there's really no implementation or nothing really happens, but
Right.
it says that in the code, and
It
we're
does.
supposed to do that. But we won't know a child is going to take that piece of property for another 6 months or 9 months. You know, I think that's kind of where our firm has we've got been between a rock and a hard spot, because we want to hit that 150 days, but we haven't decided who's taking it. We might have to get a loan from, you know, within the trust to do all
Right.
of that, but then all of a sudden the, you know, if we hit it at the wrong, I should say the sweet spot for the tax collector, but the bad spot for our client.
For your
then-
client.
Right, and it gets, you have the death of real property owner, you have no parent-to-child, no
Application.
CNC, no homeowner's exemption, and it got reassessed in September,
Yeah.
and we haven't decided who's gonna get it yet, because so that's kind of a sticky problem.
Deborah, and that goes to what we've been telling everybody for the last 20 years. It's an uncomfortable conversation to have, but you gotta sit down with your kids and ask them, which one of you is gonna want this house? Are you really want this house? And make that decision, it's just, you know, as early as they can, before they die. Because if I die, and then, you know, the clock is running, and you don't make it in a timely fashion, or your finances change for some silly reason, God knows what, you may not get the benefit of the Prop 19. So it's the most difficult conversation your clients are gonna have with their kids. Which one of you wants the house? And then put them all in the backyard and then fight about it. But honestly, you have to have that conversation. You may have a child that has special needs, and you want to have that house. And the other siblings are, God knows, jealous or self-centered enough, they're going, no, I want. So let them work that out. Earlier the better. For exactly the reason you just stated. The clock is running.
But additionally too, I mean, that this portion of the revenue taxation code is just really hard on families because they've taken that time away under Prop 58. You could just wait. I mean, we would get applications years after the parent passed away. I mean, I was really surprised to hear you say to get that affidavit of death turned in 150 days. I figured no one knew about that because we just wouldn't get notification. I mean, no, that's good, but we wouldn't get notification until
She's just showing off.
until basically they decide to sell the property to a third party, and then we get everything, which is fine, but again, this law has just fast forwarded that. You just don't have that liberty or that luxury anymore. Yeah.
So what is is there anything in the statute that requires, is there a minimum time period that they must, be the primary resident in the house after they've inherited it?
Is there a minimum? There's no minimum, it's just.
Right, so they just need to move in, file the homeowner's exemption. Do they need to, if they're moving from their house into their parents' house and they file for the new homeowner's exemption, and do they need to withdraw the homeowner's exemption on the other
Yes.
one at the same time?
Absolutely. And that is on the homeowner's exemption claim. They ask, do you have a homeowner's exemption on another house?
Got it.
And when did you move out of that house? And when are you moving into this house? So those questions are on that claim form. In addition, report is run ever so often for our homeowner's exemption department. And so if they see duplicates, you're gonna get a phone call to figure out where does that homeowner exemption, where is it supposed to go?
And then I just have one follow-up question, is with respect to, because, a lot of times the beneficiaries will sell mom and dad's property.
Right.
They don't move in, so it seems to me that with Prop 19, the baseline threshold requirement is that the beneficiary move into mom and dad's house.
Yes.
And are a resident in it. So in other words, they would not be able to take the proceeds from the sale to a third party and put it down somewhere else and qualify for an exemption.
Take the proceeds from their house.
So let's say I'm 55 years or older.
Oh.
I sell mom's house, I take my half, and I go buy another property. Can I claim the homeowner's, or can I claim the, do an exemption from reassessment if I buy something else?
Yeah, if you do it, exactly. She's exactly, if you do it right. And people were doing that under Prop 58, and I think we saw maybe one application where they tried to do it under Prop 19. So, yes, there's a way to do that. But see, the thing is, you get caught. Yes, okay, then I'll leave it at that. I'll leave it at
There was
that.
a caretaker who was in the home, she moved out of her house in LA, moved in to take care of her mom for the last year, and then didn't sell the house for about a year after her mom died.
Yeah.
So we claimed the P-19 from date of death and we distributed it to her.
I'm talking about a situation where you don't have to reside in the property.
But so your base transfer would not work, because when you do a base transfer, that the property that you sell, so your parents' property, that has to be your primary residence to another primary
Before you
residence.
sell it.
There's a way to do it, I'm not gonna tell you, but you just have, if you do it right.
You'll have to hire a really good real estate attorney.
Yes, exactly. And be careful, because like I said, we do have access to MLS and confidential remarks, so we use that. I mean, I know people have things that they're trying to do, but you can't just put everything out there and then us not. Okay, so I just want to make sure you know.
Due diligence.
Yes, due diligence for sure.
Well, we guard, the information we have in our office could be misused very easily. So to start with, we guard the information we have very jealously. It's discoverable if you really wanted to get to it. Somebody else could get to it. It could be subpoenaed. But from the average person coming in the office, the only people we'll release that information to is the owners or their designated agent. Nobody else. We won't give it to anybody else. We're really careful about that. Because you'd be surprised at people that come in and claim to be someone's cousin or their parent, and they're there to get the information because they're trying to help them out. It happens quite regularly.
Okay, we're gonna take one more question, yeah, and then we need to move on to the rest of the.
So since we lost the $1 million of assessed value for other real properties,
Yes.
not primary residence, what about change of control, change of ownership? So if we had like tire shop, family tire shop, dad, mom own the tire shop, son works at the tire shop, could parents create an LLC, they do a proportional ownership transfer to the LLC.
Mhm.
So there's no reassessment there, because it's the same.
Mhm.
Then we take it, dad makes a gift, I'm gonna give my son 49% ownership
With the
interest in the
under-
LLC. Then we take it out of the LLC, and now we have 49-51.
Mhm.
Then dad makes.
Well, let's flip, so. So, yes, right?
Yeah.
And I was chuckling because I was having this conversation at lunch, that's what we'll start to see is a lot more LLCs formed. And that is under a whole nother set of rules under the Revenue and Taxation Code. And so that's too much for me to get in, but it sounds like you know a little bit, or not. I don't want to quantify what you know, a little, a lot of it, you know, you have some information on that, but, I would encourage you to read the Revenue Taxation Code, but that is what we look at once you pass over the 50% threshold of whether it is a change in control.
Because the old rule said like legislation, the parent-child transfer.
Yes, it did.
Within, but then the new rule is totally different. So now it's a step transaction.
So it's still, you're talking about a tire shop, so that doesn't even fall under the Prop 19. You couldn't do that, right?
No,
But you could do it for
the old stuff.
but you could do it for a house that maybe you wanted to rent, and I'll just leave it at that, right?
Okay.
Because if we're doing a tire shop, then that doesn't, so once your parents add you to the commercial property, that's a change in ownership outside of the LLC. So
Yeah.
mom and dad to son and daughter, that's a change in ownership, and then to your LLC. So you need to kind of see how that works and how you can do that, but at the face of what you're saying, the tire shop wouldn't qualify for a Prop 19, so it wouldn't be a step transaction.
It could be just maybe 2% gift that you make, and then if you do more entity stuff.
If we're talking about owner-occupied property, and then you wanted to rent it, that's probably the route you would go.
Okay.
If that makes sense.
Yeah.
Okay.
All right, so let's move on to the valuation portion.
Okay, so again, now we're looking at a valuation test when we're determining what the taxable base will be, that you get to exclude. We have FBYV, that's the factored base year value. That's the transferor's Prop 13 value with no more than 2% added each year. The market value is determined by our valuation staff as of the date of transfer. The excluded amount is the factored base year value of the primary residence plus $1 million. So that's what we'll be looking at versus market value. We'll take whatever the current factor base year value, add $1 million to it, and then compare it to market value. The excess value is the full cash value on date of transfer minus the excluded amount. The new taxable value is the new assessed value based on the valuation test if applicant transferee meets all qualifications, and then I just restated it, that factor base year value plus $1 million. So that's the number we're looking, and also whatever the current factor base year value for the parent. So example one is just very straightforward. There's no excess. The transfer occurs, and it's a transfer. So the parent's alive, it's their house, I'm moving to Florida, here you go. July 5th, 2021, the factor base year value on record is $725,850. The market value is determined by our appraisal staff is 1.5. You do as you see, 1.725, and that is not greater than the market value. So in this case, you get to keep the $725,850. That's straightforward. And we have a few of those applications, super straightforward, not many though. The next one, this has excess. So the data that's transferred, they died right after the law became effective, February 17, 2020. And we had those. Factor base year value, the parents bought the property a long time ago, so it's not that high, $382,321. The market value determined by the appraisal staff is 1.8. And you do the calculation, the 1.8 versus the 1.382321. You see the excess amount is $417,679. You add that to the factor base year value. And so now your Prop 19 excluded value is $800,000 as of the transfer date and not the $382,321. So that's a big difference. And what we did see was a significant increase in Prop 58 applications before the day became effective. I mean, we're pretty much caught up on those, but I mean, it was close in the thousands that we received as far as parents trying to go ahead and, or whomever, get that property transferred before the law became effective. And you can see why. I mean, that's a big difference.
There were a lot of adult children standing on their parents' oxygen hoses in early February, trust me.
So this is an example where we have excess and an ineligible transferee. So the date of death occurs on November 15th. It went to the eligible grandson. He met all the requirements, 75%, and then to a friend for 25%. And so you can see still a low factor base year value, but you know how the market's been as of the last 2 years, 1.5. And you can just kind of go through that calculation and see. When we determine the excess, we look at that of 250,000 plus 250,000 times the 75% that the grandson receives. So that becomes 375. The friend is 25% of the 1.5. And so you can see 750,000 is the new taxable value as of that transfer date. I have one more example. This is courtesy of Esther. So this is one where it's excess, and then a portion wasn't reassessed, so spousal and a child transfer. But as you can see, underlined, there's a big difference, even still, between the factor base year value that we had on our roll versus what it will be after the Prop 19 exclusion. So this is a higher market value, so $2,225,000. Even though the spouse has 66.7%, and that's not reassessed, the son gets 33.3%, you could just go through the calculations. And so we do the excess times the 33.3. The spouse still gets 66% of the old base, and then you add those together and it's $718,042 versus the old factor base year value of $465. Yes.
So, I apologize if you're going to explain this, but what if there's two beneficiaries? So let's say parent leaves to both children and both children want to keep it as their primary residence.
Yes.
Both children get the same sort of calculation here?
Yes.
Okay.
Yes. And I wasn't, this is pretty much it. So I have two more slides and we can go into it. And so like I said before, just make sure your application is complete, fill out the homeowner's exemption claim, send in that complete copy of your trust, not just the certification. Also, and these get a little bit more complicated, but if there is an asset distribution, somebody's buying a sibling buyout, we want to have that asset distribution. Also know that we don't check everything. So just get it to us. You know, if you're saying there's stocks and bonds and monies, we're not asking for your statement for whatever that is. So, but we do need that asset distribution to see if everything is being equalized. All our forms are found on our website. I mentioned that, our homeowner exemption claim, the Prop 19 forms are on our website. Our nice picture of Mr. Gus Kramer is on our website. And also, I've listed the numbers, as I said, Esther said, I'll give this to her so that she can put that up so you have access to it. But our numbers, the homeowner exemption claim, if you have questions, specific questions regarding establishing your primary residence, the dates or any of those type of questions, that should be forwarded to them. If you have a disabled veteran, it has to be 100%. I don't want to speak too much on it, but I've also listed that number as well. And then that's it. All right.
Did I understand you correctly that the time to put in a Prop 58 transfer is within 3 years of the date of transfer
Yes,
for reassessment?
for reassessment
Does
to,
that mean that transactions that occurred in 2020 can still be done under Prop 58?
absolutely. And so if if someone passed away prior to the February 16th date, they are still under those 58 rules. And in some cases they are, they haven't figured out what they're going to do. And we'll get the application and it will fall under the 58 rules. But I didn't mean to interrupt you, go ahead.
Okay, right.
A lot of these examples are 2021. At what point can you ask for a reassessment to see if the value has now gone down as the market is adjusted? To try and bring the property taxes down a little bit.
So, that will be a Prop 8. Once that is determined, that is your Prop 13 base value. And so if the values have gone down, that's no different than, we call it a Prop 8, it's a temporary reduction. So if the market starts to go down, we'll get those requests, but that won't change your base value. That is what it is. It'll go in at 2%, no more than 2%, and be inflated no more than 2% each year. And also, I don't think I mentioned it, if that person moves out of the house, it's no longer their primary residence, and they're renting it and we catch it, what we're going to do is go back to that full market value and IF that up, and then moving forward, it'll be back to that full market value as of the date of transfer.
So you're saying Prop 8 is the temporary reduction?
It's called a temporary reduction. It is where, and so we saw that our office was inundated and starting in the 2008 decline, and so that's all we were doing with Prop 8 reductions. And so if the market value falls below the Prop 13 factor base year value, we reduce your taxable base for that year. And then we review that every single year until it comes back, if it does come back, to what your factor base year value is. In the background, it's being calculated, like I said, no more than 2%, but you're only paying on whatever that lower market value is that we determine once a year, as of January 1st of each year.
So say you have a trust and 2 kids, and say, for easy math, you got $1 million securities and $1 million house. And the trust is equally to the 2 kids, but can be non-pro-rata. You give the house to 1 kid and the securities and everything to the other, and still get the full parent child exclusion if they make that their principal residence.
Right.
Okay, without a sibling buyout for half of it.
Well, that's what we would, if equal shares, you would have to show us that they receive equal shares. If this person's receiving the house and whatever those funds or securities were, that's what the asset distribution would show us, that they did in fact receive equal shares.
But that won't be considered a buyout from one sibling to the other of half, right?
No.
Okay, all right.
So let's hit this side of the room.
Oh, let's say there's no homeowner's exemption. Supplemental taxes, is it calculated from the date of transfer or the date of death?
The date of transfer is the date of death.
Oh, okay.
Yes,
So it's
and
not
yes,
the final order for distribution.
It is, not typically, only in special circumstances, but it is the date of death, yes.
Is the assessor's office considering letting us electronically submit these documents instead of having to mail them in?
Oh.
Depends who you are.
I'm a friend of
The short answer, we have it where we can receive the trust via email. For Prop 58, it was the wet signature that we needed, so that was why it was required to send in the mail or for us to get the hard
So that's
copy.
the real property owner, all that needs to be wet signature?
Wet signatures, yeah.
Because with deeds, they've gotten around that, so I now can electronically record my deeds, and they're not getting the wet signature. Are you guys considering some way of
We are
allowing
considering
that?
We are considering it, yes.
We're considering it, but we have a real problem with security issues, to be honest with you.
Okay. Because it's been really nice to record deeds electronically. As attorneys, we now can do it since, I think, 2020.
Oh, wow.
Directly with the companies. We don't have to go through third parties.
We want to see your smiling face at the counter.
There you go.
to clarify, so if you have 3 kids and the property's gonna go, the principal residence is gonna go to 3 kids, and one of them is gonna stay there, but the other 2 aren't. So you're gonna reassess that at 2/3?
No. It just says that any eligible beneficiary has to live in the property. So to add to your question, so say that the property stays in the trust. Is that kind of your situation that you're saying for title? Are you saying that you record a subsequent document saying that it just goes to the one child?
Well, if their mom died and she says, I leave everything to the kids in one house.
Yes.
And then.
The only way we'll look at a partial transfer or a sibling buyout is if a subsequent document is recorded, just giving it to one kid. But if if it stays in the trust, the title stays in the trust, or if it goes to all 3 kids, only one person has to live in the property.
If we have situations where they're selling, right, because no one wants to deal with that, and there's gonna be a supplemental tax bill, but they're selling it and that bill shows up 6 months later after everything's sold and distributed, is there a way, you might look at this, is there a way to speed up the process of getting a bill? So
Yes, you could call for sure. We do get that in all actuality. We get those calls like, hey, I don't want to hold the money anymore. Can you hurry up and get this reassessed so I can get my bill? For sure, you can give us a call and we'll speed that up. And that was part of the reason too why we wanted to just deny it right away. If it just looked like it was a denial so that the applicant would know that that's where our office stood on this new law. And if there was something else to consider, then give us a call back. But for sure, we can speed it up for you. Reasonably. Yeah.
So, going to this gentleman's question about the multiple children.
Yes.
And I'm sorry, I have a scenario right now that I need this information for.
No worries.
So, if let's say 3 children transfers out of trust to the 3 kids in equal shares, they own the property.
Yes.
Child 1 is living in the house, let's say for the next 5 years, and then let's say child 2 decides to move in, child 1 moves out. What form does the assessor's office need to receive in order to make sure that this homeowner's exemption, or the Prop 19 exemption remains, even though the original homeowner?
Absolutely, yeah, that's a good question. So the second sibling or second beneficiary would just have to fill out a new homeowner's exemption claim.
Okay.
That's the simple answer.
Okay, so it's just that homeowner's exemption form.
Yeah.
And it would just show it's going from this child to this child, so it won't trigger a reassessment, it's just saying we remain owners, but we're just substituting primary residence.
Exactly, because say that brother wants to move somewhere else, so
Yeah.
the other sibling is supposed to make sure that we still have a homeowner's exemption claim, and then they're letting the office know that they're now the one that is kind of fulfilling what the revenue taxation code mandates.
And at any point in the future, should none of the beneficiaries live in the home, that's when you lose that Prop 19 exemption.
Yeah.
Okay, thank you.
And maybe in 5 years it'll be different, who knows?
Can you explain when what reassessments occur if there's a life estate in a trust before the property goes?
I can't, not today. But I'll leave my card and you can, because that's some of the language that they're put up for the emergency amendment. So really, we haven't received our marching orders from the state, so.
So if the child gets the exemption, lives in there, and 5 years later moves out, they lose that exemption as of the time they move out, it doesn't go retroactive.
No, they lose that exclusion as of the time they moved out, but that value will be calculated from back there and then moving forward with the inflation rate applied no more than 2% each year, moving forward, they will pay on that.
So they'll get the benefit of the 5 years
Yes.
previous lower tax base.
Yes. Yes.
Yeah, would you mind going back to one of the slides with the proportional shares?
Sure.
Yeah. Just,
the easy one?
No. But, yeah, to follow up on your question, it looked like you only do the exemption on that one whatever share is held by the eligible child who's moving in. And the rest of the
Factor based
property
share.
does get reassessed.
No, because it was a 25%.
Oh, the front.
Well, yeah, but if it's,
So-
wouldn't a child who's not living there also be ineligible?
So this one we're talking here, this
Yeah,
one?
sure.
So whether the friend's living there or not, the trust has said 75% to my grandson and
Yeah.
75% to my girlfriend. And so that's how we do this calculation. So the 25% then is based on whatever the fair market value or the market value was determined as of the transfer date.
Maybe he's talking about the other one where.
The other one.
The parent, the parent and the son,
I think that's probably the one you're saying, so we still did that 66.7%, but that was at that, so we're putting them together, so 33.7 was, or 33.3 was the child, the eligible child, and so that was based on the excess.
Yeah.
And then the 66.7 was multiplied towards that lower factor base year value, and then we put them together, so yes.
Yeah.
Mhm.
Okay. So, well, let's say you have like 4 children all taking the house.
Mhm.
Only one of them is moving in, or only one of them is continuing to live there. So then you only 25% of the property gets.
No, because if all of them were eligible beneficiaries, all we're saying is we just need one of those,
Only
at
one
least,
needs to be
at
eligible.
least. No, they all have to be eligible.
Okay.
So the trust says it goes to my 4 kids,
Yeah.
but only, they're adults, they're not gonna live in the house, only one is going to live there, and that's fine, they get that exclusion, there's
And they
no
get-
reassessable, okay?
Thank you very much.
You're welcome.
So just to clarify on this example,
Well, we're only a million.
Yeah.
That's what this is.
Yeah. Okay, that's.
okay, just to clarify on this example, and maybe you all understood this, but when there were, in this example, if there had been more than one child receiving a percentage of the house, that $1 million, that value goes to the entire house. So that's applied to the value of the house, not per child. Like each child doesn't get $1 million exemption, which I incorrectly thought. So that value goes against the total value of the property. Okay.
1 million per parent.
No.
It's per property, it's attached to the property, that's it. That's the only factor you need to know. Okay, so thank you for all those wonderful questions. We do have one last piece, which is what is the future of this law that is causing such havoc in our estate plans and all these transfers between parents and children and grandchildren? Gus, look into your crystal ball. Where is this legislation going? Are we gonna have, and more to the point, if something does change, what happens to all those properties that got reassessed?
Properties that got reassessed will continue to go forward. There won't be any retroactive assessments. I can't imagine that. There is such contentiousness over this Prop 19 that people tell me that they didn't realize what they were voting for when they lost their transfer of their investment properties. That really upsets them. I can't tell you, that's the one issue. And then Tanai is working on some cleanup language, further cleanup language to clarify some issues with Prop 19. So I think it's kind of a work in progress, and it all depends on the special interests that step up to the plate on these propositions, because cleanup legislation is easy. That's just the state legislators, wringing their hands and trying to figure out what constituency they're going to make happy. When you talk about a proposition, you're talking about, $20, $30 million to advertise it statewide. We'll start with getting signatures and then advertising it statewide. So it's going to take some special interest to clean this back up. And I don't know where that's going to come from. I thought it was going to come from the Jarvis Gann Group in Southern California. And they just put their hands and rolled their eyes and said, no, we're not gonna spend our money on this. They're worried about protecting Prop 13. They see it at risk of being taken down. Mostly because it's kind of interesting, they're seeing more and more young people getting elected to public office and who don't remember what it was like in Prop 13 and public agencies raising taxes every year. And I think they're right. I think they're going to see people say, you know what, we need more money for government, and therefore we're going to modify Prop 13. There's been two efforts out. One was to have a split roll, which was another legislation that was written by the unions. And it was it would have been insane it would have cost more to administer than it would have generated. What the Assessors Association proposed, and I'm an old Labor Democrat, and we had the far right Republicans agreeing with us, was let's do a split rate. If you really want to tax the refineries and businesses more, do a split rate. So residential stays at 1%, and businesses get taxed at 1.25%, 1.5%, whatever moves you. And the labor organizations just can't seem to bring themselves to live with that. So what the future is, it's how much money a special interest wants to put forward to put their agenda on the ballot. I can't, that's as clear as it's gonna get. But Prop 13 will be attacked regularly for at least the next decade, for sure. So, depends, whose ox is getting gored, or who steps up to the plate and puts their money in. Yes?
Ryan, I have a question.
Sorry.
Was the major sponsor for Prop 19 the California Association of Realtors?
Yes.
And they benefit immensely by forcing sale, and isn't it very similar to an inheritance tax, which California does not have?
You could argue that. You could argue that. They did, unfortunately, I'm a licensed agent, I contribute to those people. So it really pissed me off when they did it. And I tried to talk to them, and they did Prop 5, and they didn't listen to me then. So I'm not sure where the next interest is. I think the realtors got what they wanted. I think it's labor that's looking for an extra pound of flesh next year. Yes?
Yeah, I thought 19 was just a real deceitful wolf in sheep's clothing, because what was marketed was help the elderly. Well, that wouldn't pass easy. Help the wilderness victims, the fire victims. Yes, that wouldn't pass easy. What was not broadcasted was we're going to gut the parent-child exclusion. And it wasn't until I read the ballot, this is going to raise tens of millions of dollars for local government. I'm like, how can you cut taxes and raise money? And I read the fine print. I went, oh my word, they're gutting parent-child. Most people didn't understand that. I think it was absolutely fraudulent. Had it just been that on the proposition, I think it would have been denied.
The ad I liked the best for Prop 19 was a stately looking silver-haired woman with really nice pearls, a really nice dress. And it was like, why should she get to pass her property on to her children? I mean, it was like, really? It was pretty interesting. It was definitely a class or a caste system they were implying, and they played it well. I gotta give them credit where credit's due.
Well, if there are no more questions, we'll end our presentation here. We will make sure that you get the PowerPoints and the reference materials and handouts that will be available to you. Thank you so much to Gus and to Nye. Okay, make sure